Hey everyone, welcome back to the channel. Today we're looking at one of the most significant reforms to the private rented sector in decades, the changes to Section 8 under the Renters' Rights Act 2025. If you're a renter, a landlord, or you work in property, this is essential viewing. These reforms reshape how possession works, and when they come into force, the process will look very different from what we've known for years. So, grab a coffee, hit subscribe if you haven't already, and let's break down what's changing, why it matters, and what you can realistically expect once the new rules take effect. Section 1. What is the Renters' Rights Act 2025 actually changing? Let's start with the big picture. The Renters' Rights Act 2025 abolishes Section 21, no-fault evictions from May 1, 2026, meaning landlords will no longer be able to regain possession without relying on specific legal grounds. Section 8 becomes the sole legal route for regaining possession of an assured tenancy. The Act also expands and restructures the Section 8 grounds in Schedule 2 of the Housing Act 1988. The number of grounds increases significantly, and notice periods are updated. The government has confirmed that detailed guidance and finalized notice periods will apply from May 2026, with transitional rules before then. A key procedural change is that all possession claims will require a court hearing. The accelerated procedure will no longer apply once Section 21 is abolished. This aligns with the government's intention to ensure judicial oversight of all evictions. Section 2. The new Section 8 grounds, what's actually changing? Under the Renters' Rights Act 2025, the Section 8 grounds fall into three broad categories. 1. Mandatory grounds. If proven, the court must grant possession. 2. Discretionary grounds. The court may grant possession depending on the circumstances. 3. Public interest grounds. A hybrid category intended for serious or persistent issues where wider community impact is relevant. The exact numbering and final wording will be set out in secondary legislation, but the Act and published guidance outline several key changes. Small blue diamond mandatory grounds, examples. Landlord returning to live in the property, this replaces the previous, landlord moving back in, ground but with clearer evidential requirements. Landlords must demonstrate genuine intention and comply with notice periods. Serious rent arrears, the threshold is clarified and based on a rolling period to reduce tactical arrears repayment immediately before hearings. This is intended to create consistency and reduce disputes. Serious anti-social behavior, the definition is broadened to include harassment, intimidation, and persistent nuisance. This aligns with the government's aim to strengthen tools for dealing with disruptive behavior. Sale of the property, this is a new ground. Landlords may seek possession if they intend to sell, but they must provide evidence of genuine intention and comply with restrictions on reletting. This ground has been confirmed in multiple landlord guidance summaries. Small blue diamond discretionary grounds, examples. Repeated late payment of rent. Even if arrears are cleared, persistent lateness may justify possession. Courts will consider the pattern and impact. Breach of tenancy obligations, this includes damage, neglect, or misuse of the property. The court will assess reasonableness and proportionality. Loss of landlord licensing or regulatory compliance, if a landlord becomes unable to legally operate the property, for example, losing a selective license, the court may consider possession appropriate. Small blue diamond public interest grounds. These grounds are designed for exceptional cases where the behavior or circumstances have wider community impact. They sit between mandatory and discretionary grounds. Examples include criminal behavior linked to the property, severe health and safety risks, situations where remaining in the property would cause significant harm. These grounds give courts flexibility to act where the old system struggled, but they still require evidence and judicial assessment. They are not automatic grounds for eviction. Section 3. The end of accelerated possession, what court hearings will look like. Now let's talk about the biggest procedural change, backhand index pointing right. Every possession claim will require a court hearing once Section 21 is abolished. This is a major shift from the current system, where landlords can use the accelerated route for Section 21 claims without a hearing. Under the new framework, the process will look like this. Step 1. Notice served. Landlords must serve the correct Section 8 notice, citing the specific grounds and providing supporting evidence. Notice periods will vary depending on the ground and will be set out in the statutory instruments applying from May 1, 2026. Step 2. Claim issued. If the tenant does not leave, the landlord files a possession claim with the court, including the tenancy agreement, the notice, evidence supporting the grounds, compliance documents, EPC, gas safety, deposit protection, etc. Step 3. Court hearing. Every case will be listed for a hearing. The court will expect clear documentation, witness statements where relevant, proof of compliance with legal obligations, evidence supporting the ground relied upon. Tenants will have the opportunity to challenge the landlord's evidence, raise defenses such as disrepair or incorrect notice, present their own evidence. Landlords should expect more preparation, more paperwork, longer timelines compared to the current accelerated route. Step 4. The judge's decision. The judge will consider whether the ground is proven, whether the landlord has complied with all legal requirements, whether the tenant has valid defenses, whether possession is reasonable, for discretionary grounds. Mandatory grounds still require the court to grant possession if the evidence is sufficient. Step 5. Enforcement. If possession is granted, the tenant is given a date to leave. If they do not, the landlord must apply for enforcement through court bailiffs or high court enforcement officers. Section 4. How this affects renters. Let's talk about renters. 1. No more no-fault evictions. From May 2026, landlords must rely on a Section 8 ground. 2. Guaranteed court hearing. Tenants will always have the opportunity to be heard and challenge evidence. 3. More stability and predictability. The grounds and notice periods are clearer and more structured. 4. Protection against misuse of grounds. If a landlord claims they are selling or moving in but does not follow through, tenants may challenge the eviction and may be entitled to remedies depending on the circumstances. 5. Safeguards for vulnerable tenants. Courts must consider vulnerability, disability, and the impact of eviction on dependents when assessing reasonableness. Section 5. How this affects landlords. Now let's flip the coin. Landlords will face a more regulated and evidence-driven system. 1. More paperwork and preparation. Landlords must keep detailed records, including rent schedules, communication logs, inspection reports, compliance certificates, evidence supporting the ground for possession. 2. Longer timelines. Because every case goes to court, possession will generally take longer than under the current accelerated Section 21 route. 3. Higher legal costs. Hearings may involve legal representation, court fees, and expert evidence in complex cases. 4. Stronger grounds for serious issues. Landlords dealing with anti-social behavior, criminal activity, serious arrears, or property damage will have clearer statutory grounds. 5. More certainty when selling or moving back in. The new mandatory grounds provide structured routes, but landlords must comply strictly with evidence and notice requirements. Section 6. What to expect when the provisions come into force. When the new Section 8 system goes live on May 1, 2026, expect a transition period where 1. Courts will be busy. A surge in cases is likely as the system adjusts. 2. Judges will scrutinize evidence closely. With Section 21 gone, Section 8 becomes the backbone of possession law. 3. Early cases will set important precedents. Expect clarification on what counts as serious arrears, how the sale ground is interpreted, what evidence is needed for anti-social behavior, how reasonableness is applied in discretionary grounds. 4. Landlords will need to be more professional. Documentation and compliance will be essential. 5. Tenants will be more empowered. With guaranteed hearings and clearer rights, tenants will be better positioned to challenge unlawful or poorly evidenced claims. Section 7. Final thoughts. What should you do now? Whether you're a renter or a landlord, preparation is key. If you're a renter, understand your rights. Keep communication records. Report disrepair promptly. Seek advice early if you receive a notice. If you're a landlord, ensure compliance with all legal obligations. Keep detailed records. Use written agreements. Seek legal advice before serving notices. Prepare evidence early. The Renters' Rights Act 2025 aims to create a fairer, more transparent system, but it also requires more diligence from everyone involved. Thanks for watching. If you found this breakdown helpful, hit like, subscribe, and drop your questions in the comments. I'll be covering more updates on the Renters' Rights Act, including deep dives into each new Section 8 ground. See you in the next video.